I come to the floor today to ask a fundamental question. Who will benefit from the TPP? American workers, consumers, small businesses, taxpayers, or the biggest multinational corporations in the world? One strong hint is buried down in the fine print of the closely guarded draft. The provision, an increasingly common feature of international trade agreements, is called Investor Dispute Settlement, or ISDS. Now, the name may sound mild, but this provision fundamentally tilts the playing field further in favor of big multinational corporations. Worse yet, it undermines U.S. sovereignty. ISDS allows foreign companies to challenge American laws and potentially pick up huge payouts from taxpayers without ever stepping foot in an American court. Now, here's how it works. Imagine that the United States bans a toxic chemical that is often added to gasoline. We ban it because we believe it is dangerous for people's health or harmful to the environment. If a foreign company that makes this toxic chemical wants to sell it in the U.S., it would normally have to challenge that in a U.S. court. But with ISDS, the company could skip the U.S. court and go before an international panel of arbitrators. If the company wins, the ruling cannot be challenged in U.S. courts, and the arbitration panel could require the American taxpayers to cough up millions, even billions of dollars in damages. ISDS has the power to impose gigantic fines, but it doesn't have independent judges. Instead, highly paid corporate lawyers go back and forth between representing corporations one day and sitting in judgment of corporations the next. Now, I don't know, maybe that makes sense in an arbitration between two corporations, but not in cases between corporations and governments. We should have real doubts about how likely it is that a lawyer looking to attract high-paying corporate clients will rule against those corporations when it's his or her turn to sit in the judge's seat. It's also a real problem that the only international investors get to use these courts. Investors that are, by and large corporations. If a Vietnamese company with American operations wants to challenge an increase in the U.S. minimum wage, it can use ISDS. But if an American labor union believes the Vietnamese companies are paying slave labor wages in violation of trade commitments, the union has to try to wind itself through the Vietnamese courts. Good luck with that. These rigged pseudo-courts were created after World War II because investors worried about putting money into developing countries where the legal systems were just not as dependable. They were concerned that a corporation might build a plant today only to watch a dictator confiscate it tomorrow. ISDS was born to encourage foreign investment in countries with weak legal systems. Now, look, I don't know if these justifications made sense back then, but they sure don't make sense now.